Welcome back to the deep dive. So, navigating Social Security disability hearings. It's complex. The stakes feel incredibly high. And right there in the middle of it, you might encounter this figure, the vocational expert. They talk about your ability to work, and it can feel like your whole future hangs on their words. Today, we're going to pull back the curtain on that role, make it less mysterious, more like something you can actually understand and, navigate confidently. We're drawing on a really comprehensive guide today. It's written for claimants, packed with insights. It's got a focus on Virginia's shore, but honestly, the strategies, they apply pretty much everywhere in the U.S. So our mission today, it's not just to explain what a vocational expert, or VE, does. We want to uncover those leverage points, the ways you can really look closely at their testimony and maybe, just maybe, help shape the outcome of your claim. It's about being strategic, not just informed.
That's exactly right. It can definitely feel intimidating, that whole process, but understanding the details, it really does give you power. It lets you approach things with more clarity, more confidence, too.
Okay, let's dive right in then. Who exactly is this vocational expert in an SSD hearing? What's their, main job?
Right. So a VE, a vocational expert, they act as an impartial witness. Their basic function is to give testimony about jobs. Things like, are there jobs available? What do those jobs actually require someone to do? And crucially, could someone with the specific limitations being discussed actually perform that kind of work? They need to have a really deep knowledge base. We're talking national job markets, regional ones too, what different occupations demand physically, mentally. And the Social Security Administration, the SSA, they rely on this testimony quite heavily. It helps them figure out, okay, can this person go back to their old job? Or if not, is there some other kind of work they could switch to even with their disabilities? Their input is particularly vital when the judge, the administrative law judge or ALJ, has to make that final call. Does this person meet the official definition of disabled according to Social Security rules?
Okay, that makes sense. So if their testimony is that important, what kind of qualifications do these VEs usually have? What gives their opinion so much weight?
Well, typically they'll have advanced degrees, things like vocational rehabilitation, maybe psychology or, related fields. But what's really fascinating and what adds the weight isn't just the diploma. It's the sheer breadth of specialized knowledge they need. They absolutely have to know the Dictionary of Occupational Titles, the DOT. That's kind of the Bible for job descriptions. Plus, labor market trends, how to assess functional capacity, vocational rehab methods, job placement, even workplace accommodations. It's this comprehensive expertise that lets them connect your specific medical limits to what jobs actually demand in the real world. That's why their opinion is often so persuasive to the judge.
Wow, okay. They sound like really influential people in these hearings. But how often do they actually get called in? Is it every single time or only in certain situations? And how much do they really sway the decision?
Yeah, they are influential. But no, they don't testify in every single hearing. It's quite common, though. Statistics suggest VEs are involved in maybe 70 to 80% of SSD hearings. It's especially common when the claimant still has some ability to do work-related things, what's called residual functional capacity, or RFC. The ALJ usually brings them in specifically for steps 4 and 5 of that 5-step process SSA uses. Those are the really critical questions. Step 4 is, can you do your past relevant work? And step 5 is, okay, if not, is there any other work out there in significant numbers in the national economy that you could do? So, if your RFC suggests you can still do some kind of work, the judge needs the VE's help to pinpoint exactly what jobs might fit, given all your limitations.
Right, and that's where all the individual details about the claimant start to matter intensely, isn't it? Like, how do things like your age or how much education you have, how do those specifically play into whether a VE gets called, or maybe how their testimony is viewed?
Exactly. Those factors are key. The SSA actually uses specific guidelines for this, often called the Medical Vocational Guidelines, or just the GLID rules. These rules look at age categories. Are you considered younger, closely approaching advanced age, or advanced age? They look at your education limited, high school grad, maybe higher ed, and they look at the skill level of your past jobs. Was it unskilled, semi-skilled, or skilled work? Now, if connecting all those dots using the GRID rules doesn't lead to a clear-cut decision on disability, well, that's often when the VE testimony becomes absolutely essential. They sort of bridge that gap between the medical facts and what you can actually do in a work setting.
Okay, so let's say the VE is called. What kinds of questions should you, the claimant, expect the judge to ask them during the hearing?
The judge usually asks the VE hypothetical questions. These are designed to mirror your specific limitations based on the medical evidence presented. So the hypothetical will bundle together different kinds of restrictions. It could include physical limits, like how much you can lift or how long you can stand or walk, Mental limitations, too, maybe problems with concentration, memory, or getting along with coworkers or the public. Environmental restrictions can be part of it, sensitivity to dust, fumes, temperature extremes, and sensory limits, too, like issues with vision or hearing.
We've talked physical, but what about mental health? That's a huge factor for so many claimants. How do things like depression or anxiety factor into what the VE says? Are they given the same importance as, say, a physical injury?
Oh, absolutely. Mental health limitations are incredibly significant, and VEs are required to consider them fully. Conditions like severe depression, anxiety disorders, PTSD, cognitive issues, these directly impact things essential for work. We're talking about the ability to stay focused, handle normal workplace stress, interact appropriately with bosses and colleagues, even just show up consistently. These are just as critical as physical limitations in determining if someone can work. So, yes, the hypothetical questions the ALJ asked the VE must accurately reflect the seriousness and the impact of those mental health conditions on your ability to function in a work environment. They carry significant weight.
Could you give us some example, like a concrete example of a typical hypothetical question, just so we can really picture how this works?
Sure, yeah. A typical one might sound something like this. Mr. N's vocational expert. Assume we have an individual of the claimant's age, education, and past work experience. Oh, whoa. Assume this person can lift, say, 10 pounds only occasionally. They can sit for about 6 hours in an 8-hour day, but only stand or walk for 2 hours total. Quote. Further assume, the judge might say, that this individual has a marked limitation in their ability to concentrate for extended periods and moderate difficulties interacting appropriately with the general public. Based on that hypothetical, could such an individual perform the claimant's past relevant work as a retail manager?
Ah, okay.
And then the VE has to analyze that. They'd compare those limitations against the demands of a retail manager job, either how it's generally done across the country or maybe how the claimant specifically performed it.
Okay, that example really helps. It sounds like this is a really crucial point in the hearing, a point where you absolutely need to be ready. So what are the best ways for someone to strategically challenge what the VE says?
Preparation is everything here. And, a key insight is that sometimes the most effective challenge isn't a direct confrontation. It might be about subtly pointing out inconsistencies, maybe things the VE hasn't fully considered. But one of the most powerful tools is finding differences between what the VE says and what's in the Dictionary of Occupational Titles, the DOT.
The DOT again.
Exactly,
Yeah.
because that's supposed to be the standard reference for job requirements.
So what specific kinds of inconsistencies with the DOT should someone be listening for?
Well, you'd look for clashes between the physical demands the VE describes for a job and what the DOT actually lists for that same job code. Or mental requirements, too. Also, watch out for outdated job information. The DOT hasn't been updated in a long time, so does the VE's description reflect how jobs are actually done today? Other things. Maybe they misclassify the skill level, say, calling something unskilled and the DOT says semi-skilled, or getting the educational requirements wrong. And definitely pay attention to the job numbers they give. If they say there are thousands of jobs available, does that seem realistic? Are those numbers consistent, or do they contradict other data?
Okay. That leads right into the next step then. If you spot a potential issue, how do you actually challenge it through cross-examination? What kinds of questions should you or your attorney be prepared to ask?
Right, cross-examination is key. You want to probe a few core areas. First, their methodology. Ask things like, how exactly did you arrive at those job numbers? What sources did you rely on? Are those sources current and generally accepted in your field? You want to understand their process.
Okay, methodology. What else?
Second, market reality. This is huge. Questions like, okay, you've identified these jobs. Do they actually exist in significant numbers right here in this region? Are employers actively hiring people for these roles now?
Because a job existing on paper isn't the same as a real job opening?
Precisely. A job might theoretically exist nationally, but maybe not practically where the claimant lives. And third, accommodation requirements. You might ask, would the jobs you identified require specific accommodations for this person's limitations, like extra breaks, a special chair, reduced public contact that employers in this field typically don't provide? Asking these kinds of pointed questions can definitely highlight weaknesses or maybe impractical aspects of the VE's testimony.
And what if that market reality question hits home? What if the jobs the VE names just don't seem to be available in your specific town or region, or the numbers feel inflated?
That's a valid challenge. You absolutely can and should challenge testimony about job availability if it doesn't square with the local reality. The way to do it is by presenting evidence. Evidence about the actual job market conditions right there in your area. This might involve data on local hiring trends, statements from employment agencies, maybe even evidence showing a lack of relevant job postings. Your attorney can be really helpful in gathering this kind of specific local evidence.
Okay, so gathering evidence is critical. What are the most important steps someone should take before the hearing to get ready for the VE's testimony?
Preparation starts way before you walk into that hearing room. Gathering strong supporting documents is crucial. Things like detailed job descriptions from your past employers, not just titles, but what you actually did. Any records of accommodations you received at work? Evidence if you tried to go back to work and it didn't succeed. Letters from old supervisors, if possible, describing your limitations on the job. And if you've worked with vocational rehab services, any records showing job placement attempts that didn't pan out. All that helps paint a picture. Beyond documents, you need to thoroughly review your own work history in your mind. Be ready to talk specifics. What were your exact duties? What were the physical demands? The mental ones? What skills did you use? Were any transferable? Think about any accommodations you got. Why did you leave each job? Critically, detail any times you tried to return to work but couldn't manage it due to your health.
Got it. So knowing your history inside and out, what about common mistakes? What are the pitfalls people often fall into when dealing with VEs that could hurt their claim?
Probably the biggest mistake is simply failing to challenge testimony when it's questionable. But it's more nuanced than just objecting randomly. It means not speaking up or not having your attorney speak up when those hypothetical questions from the judge don't accurately reflect all your documented limitations. That's a big one. Also, failing to point out those inconsistencies with the DOT we talked about. Or just accepting unrealistic job numbers without questioning the basis, not probing the VE's qualifications or their methodology if something seems off. And the other major pitfall is just overall inadequate preparation. That could mean not having enough documentation about your past work or your limitations, not really understanding the demands of your previous jobs yourself, or not gathering evidence beforehand that might contradict what the VE is likely to say, and, crucially, not working closely enough with your attorney to plan those cross-examination questions. You have to remember, the VE is an expert witness, not your personal career counselor. Their testimony needs scrutiny.
So pulling all this together, what does it really take to maximize your chances of a successful outcome when there's a VE involved in your hearing?
Okay, maximizing your chances. First and foremost, working with an experienced Social Security disability attorney is usually paramount. They'll know the DOT inside and out or know how to use it effectively. They understand how to conduct cross-examination, how to spot weaknesses in the VE's testimony, and they can present alternative evidence and frame legal arguments effectively. That legal expertise is huge. Second, you need robust medical evidence, really detailed functional capacity evaluations from your doctors, clear statements about your specific work-related limitations, documentation of any times you tried to work and failed because of your condition, evidence that shows the severity, the frequency, the unpredictability of your symptoms. The medical side has to be strong. And finally, you need to build a compelling narrative for your case. Document the real-world difficulties you have trying to hold down a job. If the VE's testimony clashes with the DOT or the actual job market, your attorney needs to hammer that point home. You need to clearly show how your specific medical conditions prevent you from doing the types of jobs the VE identifies. Really highlight that gap between a theoretical job existing somewhere and your practical ability to actually get and keep that job.
That's incredibly helpful. We've really unpacked a lot here from the VE's basic role, their qualifications when they testify, the questions they answer, and most importantly, how you can strategically prepare and challenge their testimony.
Exactly. And it makes you think, doesn't it? How important it is not just to know the rules of any system, but to really grasp the strategy involved, how information gets presented, how it gets questioned, especially when the stakes are high.
It really does. Hopefully, this deep dive gives you a different perspective, maybe helps you feel more prepared for any kind of important evaluation, whether it's this kind of hearing or something else entirely. You've got a blueprint now, a way to approach this part of the SSD process with more confidence. You're empowered with knowledge. We really hope you'll continue exploring these complex topics with us on future deep dives.